you know, the United States prides itself on having the world's greatest criminal justice system. Perhaps it does, but that system has many problems. Before coming to work at UCI, I wrote about many wrongful convictions during my 30 years at the Los Angeles Times. That gave me an appreciation of this issue in many respects, but I want to say today I cannot overstate how important it is that the work of the registry puts those problems into bold and permanent, and I want to emphasize the word permanent, relief. At the time I left my office, just a few minutes ago, that's why I was late, there had been 2,224 exonerations in this country of wrongfully convicted people. And as the registry website points out, that is 19,610 years of life lost. Men and women have been exonerated in states from California to Maine, including people in Orange County. There are many reasons for the wrongful convictions, including mistaken IDs, police misconduct, horrible forensics, false confessions, among other things. And although wrongful convictions are not limited to people of color have certainly been disproportionately affected. You can read a very good study about the impact of race on wrongful convictions on the registry website. I'll just cite one figure of some note. If you are a wrongfully accused African-American male, wrongfully accused of murder, you are 7 times likelier to be convicted than if you were a wrongfully confused white male. Mind you, you will hear from a white male today who was wrongfully accused and spent a long time in prison for a crime he did not commit, but race has definitely been a factor. The registry is celebrating, if I may use that term, its first anniversary here on the UCI campus. As I said, it has creating a permanent record of horrific mistakes. I don't know if I would call them all mistakes, because some of them weren't mistakes. They were deliberate acts. You've heard about some of them, no doubt. There was a film made about 5 wrongfully convicted young men, known as the Central Park 5, who were, wrongfully accused and convicted of raping and brutally attacking a woman who came to be known as the Central Park Jogger. But many of these other cases did not get nearly as much publicity in the moment or have been forgotten. As recently as 20 years ago, well within the lifetime of everyone in this room, there was a horrific scandal in Los Angeles known as Rampart, where over 150 mostly Latino males were wrongfully convicted of mostly drug crimes. I suspect that hardly any student on this campus has heard about the Rampart scandal. Even worse, and you can read also about this in a great registry report, there were over 800 people wrongfully convicted of drug crimes in Philadelphia in a 5-year period just a few years ago. It turned out that one Philadelphia police officer had framed literally hundreds of people. I have to say, I followed this issue pretty closely. I was not aware of that until I read the registry report that was issued last year. I just want to say that whether mistakes or not, it's important to keep in mind that we're not just talking about statistics here. We are talking about people who spent a long time in prison, their lives and their livelihoods and those of their loved ones were forever altered. There are real consequences to these issues. And I think it is particularly important in an era of alleged false news, when as of today, according to the Washington Post, the President of the United States has a documented record of 3,000 false or misleading statements in a mere, 16 or 17 months in office, that it is very important that we keep truth front and central, and that the work of the registry, along with innocence projects around the country, is critical to keeping a focus on both individual horror stories and systemic problems that need to be cured. So with those few introductory remarks, I would like to now, it's my pleasure to introduce Nancy Guerra, who is the Dean of Social Ecology here at UCI. Welcome, Nancy.
Thank you so much. I'm sorry I was late. I was driving around the parking lot for 10 minutes. So this is so popular that you're all here and there was nowhere to park. I'm so pleased to officially welcome you on behalf of the School of Social Ecology. How many of you are familiar with the School of Social Ecology? Oh, good. A lot of you are. Wow. So you could, if I asked you, you could tell us what social ecology means and why we have a school named in that fashion. But one of the things that we're really passionate about is science in action. And science in action around issues such as social justice, something that I think deeply concerns every faculty member in our school, our students, and hopefully concerns all of you. And so we really couldn't be more pleased than to have a very deep association with the Newkirk Center for Science and Society and the Exoneration Project, the type of work that they do to really use data, to use information to shed light on the truth that is happening in the world. And I'm just personally appalled. I don't have the data to present you. I can just present you my emotional reaction that there are just so many travesties of justice, this being one of them. And I personally feel that a university has an obligation and a commitment to address these, and to address these doing what we do best, which is to gather information and present information. And so we are so pleased that you're all here tonight, and I don't want to interfere with all of the speakers who will give you this information and share with you this information. So with that, let me turn it over to our esteemed former dean, who is an expert in this field, and we'll talk about some of the work that he's done. Former Dean, Professor Dr. Ron Huff.
Thanks very much, Nancy. It's a pleasure to be here with you. I appreciate all of your attending today. It's wonderful to see this great turnout. I thought I would talk a little bit about where we've come from. I began researching wrongful conviction in the mid-1980s when I was a faculty member at what is now the John Glenn College of Public Affairs. John Glenn was one of the last two I appointed to the faculty, by the way. An American hero, but the whole college is named after him now. And back in the 1980s, when I began doing this research, people would frequently say, "Why are you wasting your time on this when all these guilty people are going free?" And as many of you know, every time we get the wrong person, there are two errors involved. One is the injustice. The other is that typically the real offender remains free to commit more crimes. So there are two errors with this type of wrongful conviction, and it's a very important thing. So we've come from that period of time when we had no national database. We had no real way of telling how frequent this was. We made some early estimates that were probably too low, but based on conservative sample. And more frequently, we think it's somewhere between, as Sam Gross would tell you, probably between 1% and 5%, somewhere in that range, but it's impossible to know precisely. So I want to congratulate Sam, first of all, my colleague from one of my alma maters, the University of Michigan, for having the vision, along with our colleague Rob Warden from the Center for Wrongful Convictions at Northwestern, for founding the National Registry originally back in 2012, 6 years ago, having the vision to begin this journey, and now to have it hosted here. I'd like to thank Martha and Jim Newkirk, my good friends, and Martha I've known since I was here the first time as a faculty member in the 70s when she was a student, and Jim I've known for many, many years. And their support in starting the Newkirk Center has been indispensable and a very tremendous asset to the university. I'd also like to thank Barbara O'Brien and our colleagues from Michigan State University for partnering with us now that we have the center here, this three-way partnership of UCI, Michigan, and Michigan State. It's an important collaboration, and I think a very prestigious one. So what I'd like to do with the remainder of my time is try to illustrate, first of all, some of the value of the National Registry with respect to research possibilities, and then illustrate an attempt I tried to make to use some of the data 2 weeks ago, but was thwarted by the rulings of a judge. Let me start by saying that a colleague of mine, Brian Force from American University, and I decided that an important thing we might be able to contribute was to try to estimate how many violent crimes might be prevented each year if we could simply get the right offender, the real perpetrator, and not convict the wrong person. So we wrote a paper called Preventing Violent Crimes by Reducing Wrongful Convictions, which is published in the Cambridge Handbook of Violent Behavior that just came out. And what we tried to do is triangulate several different databases using the NRE database, the Innocence Project's database, which is limited to DNA cases, and the FBI's national arrest data. I won't go into all of it's a 37-page paper, but let me just summarize. Starting with the Innocence Project, they documented 147, at the time we wrote the paper, 147 actual perpetrators who were not brought to justice due to the convictions of the wrong persons. As many of you know, the Innocence Project uses DNA, and when the DNA shows that someone didn't commit the crime and they're exonerated, if you put the DNA back in the system, many times they find out who did commit the crime. The sad part is many prosecutors refuse to put the DNA back in the system because they're so caught up in tunnel vision and denial, they won't admit they made a mistake. So there are still perpetrators that loose out there because no DNA was put back into the system. So those 147 individuals identified by the Innocence Project were known subsequently to have committed 146 additional violent crimes for which they were convicted. So that's a conservative estimate. We think they probably committed more. So about one violent crime per offender. Very likely higher. Now, if we turn to the NRE's more inclusive database where we have both DNA and non-DNA cases, and we extrapolate, at the time we wrote the paper, there were 1,851 exonerations. 1,125 of those clearly involved violent crimes, including murder, sexual assault, and robbery. Extrapolating from the Innocence Project's data to the more inclusive and comprehensive NRE data, we can logically infer that if each of the actual perpetrators committed only one additional violent crime, that group alone would have accounted for more than 1,000 additional violent crimes, some with multiple victims, committed by the actual perpetrators. But we know, as Sam and myself and others have pointed out, that's only the tip of the iceberg when it comes to wrongful convictions. Let me illustrate this another way by a study that was done, a unique, as far as I know, a unique and valuable study done in North Carolina by my colleague and friend Frank Baumgartner, a distinguished professor of political science at the University of North Carolina, Chapel Hill. By the way, he's the husband of Jennifer Thompson, who many of you know is an outspoken advocate for the innocence movement. So Frank and his colleagues, using NRE, National Registry of Exonerations data, and supplementing it with some wrongful convictions that occurred in North Carolina prior to 1989 when the NRE data began being recorded. They analyzed 36 known exonerations in North Carolina using official records. They then identified 8 cases with known perpetrators in their sample. Following up on the criminal histories of those 8 perpetrators, they discovered subsequent crimes were committed in 6 of those 8 cases. Those 6 individuals were arrested and convicted of 99 subsequent crimes, including 35 felonies and 16 crimes of violence. So that's 2 to 1. We said before, one each. They had been convicted of 2 violent crimes each. And they noted that because they lacked complete data, these were conservative estimates. And by the way, the 36 exonerees had collectively served almost 400 years in prison for the crimes that they did not commit. So it's not possible to say with precision exactly what percentage of wrongful convictions occur each year involving violent crimes, but we know that if we could be more accurate, we could certainly prevent a lot of violent crimes in America by getting the right offender, the actual offender, instead of an innocent person. Finally, my second example is a personal example from 2 weeks ago that shows how I tried to use NRE data but was precluded from doing so by the rulings of a judge. This was a case in the state of Illinois. At the time, I was not able to travel, so I testified by videographer from my home here in San Clemente to the courtroom in Illinois. This was a case that was a second trial ordered by the Illinois Appellate Court because in the first trial, the judge had made prejudicial rulings excluding a psychologist from testifying and several other key defense witnesses. So it was sent back for a second trial. I thought that some of the NRE data were extremely on target with this particular case. And so in my expert report, I cited NRE data. When it came time for me to testify, the state's attorney objected. The judge ruled that I could not use NRE data. Now, this is not totally unexpected in the sense that judges have often ruled that aggregate data cannot be used in a case because they say, well, that doesn't show what happened in this individual case. In statistics, we call it the aggregate fallacy. So in death penalty cases, that's often been an objection. What was more surprising to me was as the defense attorney went through my credentials to qualify me as an expert and asked me about my degrees and so forth, and he asked me about awards, I said, well, back in the 90s, I received the American Library Association Award for my co-authored book with my Israeli doctoral student, Convicted but Innocent, Wrongful Conviction and Public Policy. Objection. State's attorney objected, the judge upheld it. I could not mention the title of my book. I was subsequently prevented from using the terms wrongful conviction, exonerations, miscarriages of justice, criminal justice system errors, or errors of justice. Every one of those triggered an objection upheld by the judge, a former prosecutor, I might add. So I was not able to use any of those terms, which, needless to say, sort of left me with one hand tied behind my back in talking about what I believe could be a wrongful conviction in this case. So we have a long way to go. We have a lot of prosecutorial misconduct. We have a lot of unfair, in my view, judicial rulings that stack the deck. And we have a flawed justice system that results in far too many of these errors. Thank goodness we have the National Registry of Exonerations, and I'm proud to say that I'm involved with it. Thank you.
Thanks very much, Ron. And for those of you who were here last year, I mentioned that one of the reasons Sam Gross, the co-founder of the National Registry of Exonerations, chose UC Irvine was because of the strength of our faculty in this area, which comes from many people, including Elizabeth Loftus, who's here. But very important in that group was the fact that we had a dean who studied wrongful convictions, Ron Huff. Thank you. I just wanted to say a couple of things about 1 year ago, or around 1 year ago, in March of 2017, we had the kickoff event for the registry here at UC Irvine, and I wanted to say a couple things about what's happened in the year since then. Since then, we've added about 223 cases to the registry. That's about 163 what we call new exonerations, exonerations that occurred recently, and 60 what we call old exonerations, that is exonerations that, that aren't recent but that we didn't know about until we discovered them during the past year. A new exoneration database called Exonerations Before 1989 was launched, has over 300 cases in it. The cutoff date of the registry proper is exoneration occurs after in 1989 or later. So this counts the cases where exoneration occurred before then, going all the way back to the 19th century. We've developed as an organization. Clara Stevens, who's here at the end of the table, was our excellent junior researcher, was designated the Denise Foderaro Research Scholar, and you're going to hear from her later. And we have plans to hire a second senior researcher, expanding the organization by 50%. We've been successful in advancement. We had a successful year-end appeal. We got a major new gift from Martha and James Newkirk, who are here, and we're very grateful for that as well. We have research projects going on. We have an official misconduct research project an enormous project that continues. I'm working on a forensic science project. We have a project on the factual basis of exoneration, which you'll hear more about from Clara in a few minutes. We have research going on false confessions, a topic we'll hear about from Kelly Loudenberg in a few minutes. And we have research going on conviction integrity units, and Barbara O'Brien will talk a little bit more about what those are. We received extensive media coverage. We can't count all the mentions. They happen every couple of days. But here's some prominent ones in the New York Times, the Atlantic, the NPR, San Francisco Chronicle, and so on. And we have new opportunities to move further as an organization, but I'm going to have the co-founder and senior editor Sam Gross talk about some of those. So, Sam.
Thank you, Simon. And I'm organized. And it's a pleasure to be back. I was here at the event that Simon just told you about. It was wonderful. And I am thrilled that the registry has found a home at UC Irvine, and especially at the Newkirk Center. I'm going to talk very quickly about a couple of things that are going on. First is the project that Simon mentioned, a major research project on official misconduct. Here's what I'm going to say about it. Ask again in about 6 months. It's been going on for, by this point, about 4 years. We've collected a huge amount of data. We're now in the process of data analysis and writing. Keep posted. Okay? It's going to be really interesting. The second thing I want to talk about in a little more detail is what we call group exonerations. And here's the starting point. So this is the opening page of the registry website as you see it today. And if you look up there, you see that it refers to 2,224 exonerations, as I think 2 or 3 people have already mentioned, which is quite a bit. This is the page as it looked a couple of weeks after we opened in 2012. And it lists, at this point, I think it's 893 or so exonerations. When the date we opened was actually 891. We've added a lot since then at the rate that Simon was talking about, a couple hundred a year. Okay. But this is the article that appeared in the Los Angeles Times when the registry was launched in early 2012. Registry tallies over 2,000 wrongful convictions since 1989. How did we get there? How do we get to 2,000 from that? And the answer is, you'll see it in this next one, this is an AP article, is that the registry database, compiled and analyzed, contains information on 873 exonerations for which we had detailed evidence. That's a slightly smaller number than we had, but the number that we wrote a detailed report on, and nearly 1,200 other exonerations for which they have less data. Those are what we call group exonerations. Here you see a list of the ones we know now. You see they total about 2,500 altogether. This is a slightly enlarged version, gives you a slightly better view. What are they? These are groups of cases in which police officers deliberately framed innocent defendants for crimes that did not occur. With one exception, the second one you see there on the list, the drunk driving cases in Oakland, New Jersey, where the exonerations occurred in 1995. With one exception, these are all basically some of the most obnoxious products of what we call the war on drugs. These are cases in which police officers individually in some cases or usually in groups set out to frame defendants for drug possession and occasionally also gun possession in crimes that never occurred, mostly to advance their careers or to cover up other crimes that the officers were committing, extorting money from drug dealers, selling drugs on their own, and so forth. And that happened rather more often than we realized. We started running into these cases in the process of assembling the information on the databases that we eventually created. And we knew about a couple of them, and then as we were searching to find other exonerations we didn't know about, we started running into more, and then we started searching for all of them. And we knew about exonerations totaling about 1,200 or more cases by the time that we went public in June of 2012 as, whoops, no, I'm going the wrong way. I see it go up there. But as you can see on this slide, as of today, we know of approximately twice as many individual cases. Why don't we include these cases in the registry together with all the others? Well, there are a variety of answers. I'm going to mention a couple of them just very quickly, but mostly it's because they're fundamentally different sorts of cases. These are cases which are not generally the products of individual investigations of the guilt of particular defendants, but rather cases in which a police officer or a group of several police officers are identified as people who are going out and doing this systematic process of framing innocent defendants for crimes that didn't commit. And once those officers are identified and the scandal has come to light, then what happens is that lots of cases get cleared and the defendants are exonerated one after another with relatively little, or in some cases very little, attention to the individual cases. That's why you get large numbers. It also means that we sometimes know very little about the cases. In some cases, for example, in the Rampart exonerations in Los Angeles that Henry talked about earlier, we not only don't know the names of many of those who were exonerated, we have at best estimates of the number of people who were exonerated. We have very little information about them. The process that creates them is very different. It became clear to us that we couldn't study them systematically on an empirical basis in the same category as the individual exonerations. But we thought they were very important, and we said in our report, we'll get back to this. You know, these are really important cases. They're exonerations. They're just a different category. Not much is known about them. They get much less attention than you'd imagine, given the number of defendants who are involved. We need to give them more attention. We'll get to it. But we didn't until now. We're beginning to this year. This is a little excerpt from the report on exonerations in 2017, which is being handed out here, a version of it. And it mentions group exonerations. In addition to the 139 individual exonerations we report, we knew about a whole bunch of exonerations. I think it's 96 in a couple of groups that occurred in that year, in 2017, in Chicago and in Baltimore. That's a change. Most of the group exonerations were ones that we heard about and learned about years after they were over. These were going on in real time. And that has lit a fire under us. We're planning now to start making this a major part of our work, and starting perhaps in 6 or 10 months, there will be a part of the registry website that's devoted to group exonerations and that begins to discuss these cases. It'll probably be a year or two before it's fully developed, because these are each one is an individual research project. But we are now at the point where we're going to start making good on our promise from 6 years ago to give these cases the attention that they deserve. And that is all I have to report. Thank you.
It's now my pleasure to introduce Barbara O'Brien,
who is a distinguished law professor at Michigan State University in Lansing, Michigan, and she is also the editor, meaning the current chief editor of the NRE. Welcome, Barbara.
Thank you so much for coming this evening. We are so grateful, as Sam said, the home that the registry has found here at the Newkirk Center and for the support that we've received. We simply couldn't do what we do without the support of people who believe in our mission. And you've heard, thank you, okay. You've heard a bit about our mission tonight and how we count things and we tell stories and why we do that. Telling the stories of individual miscarriages of justice is important and essential to appreciating the human toll that they take. But looking at them in the aggregate, untangling the patterns and trends in both how wrongful convictions happen in the first place and how they are remedied tells us something critically important too. I'm going to use my time to give you a few highlights from the 2017 annual report, which we released in March. Our annual report provides an opportunity to take a step back and see how patterns and exonerations are changing. It helps illuminate the bigger pictures, the bigger patterns about wrongful convictions, mapping how innocent people get convicted and how that injustice gets corrected. So first I'll give you a brief overview of what we found in 2017, and then I will talk about what it might mean in a larger context. There were 139 exonerations that we learned about in 2017, and that's a lower number. That's fewer than in previous several years. So does that mean that exonerations are winding down, that the backlog of injustices are largely corrected and exonerations have run their course? I can assure you that's not true. The reduction can be explained entirely by one county, Harris County, Texas, which is Houston. Harris County has been, for the past several years, correcting many cases of false pleas and drug possession cases. In these cases, innocent defendants pled guilty to drug charges before the lab test, confirming that they were in fact drugs, came back. And sometimes those tests came back negative, but no one ever really bothered to check up on it because at that point the defendants had pled and everybody had moved on. But once this was discovered that this was happening, the Harris County Conviction Integrity Unit worked to fix those errors. And that process produced many exonerations, and that process, it does seem to be winding down. The remaining exonerations that we see, those that were not those Harris County exonerations, look remarkably like those from previous years. And in fact, we even saw some new records in 2017. So there were 84 exonerations that involved some form of official misconduct. Prosecutors' failures to disclose exculpatory evidence, police officers who manipulated witnesses or coerced defendants into falsely confessing, or forensic analysts who overreached in arriving at their conclusions. The majority of these cases with official misconduct last year were for homicides. 84% of the homicide exonerations in 2017 involved some form of official misconduct, and often several different types of misconduct by multiple actors. There were also a record number of cases with false confessions, 29, and a record number of cases involving perjury or false accusation, 87. But the most striking thing that we observed, or perhaps the most interesting thing we observed in 2017, however, was the record number of exonerations that were secured with the help of a professional exonerator. And by a professional exonerator, I mean either an innocence organization or a conviction integrity unit in a prosecutor's office. Innocence organizations, or as I'll refer to them, IOs, are non-governmental organizations dedicated to helping secure exonerations. Conviction integrity units, CIUs, are divisions within prosecutors' offices that are dedicated to reviewing possible cases of wrongful conviction. Both types of organizations have proliferated in recent years, especially CIUs. There were 33 CIUs in operation in 2017. That's more than double the number there were in 2013, and more than 6 times the number there were in 2011. Now, there are thousands of counties in the United States, so 33 isn't huge, but the rate of change is quite steep. IOs have been around a bit longer than CIUs, but they too are increasing in number, and they are playing a role in more and more exonerations. In particular, 42 exonerations in 2017 involve CIUs, part of the 278 that they have helped secure since 2003 when the first one was formed. More than 80% of those 278 exonerations have occurred in the last 5 years. Now, I mentioned Harris County and the big part that its CIU has played in producing exonerations in the last several years. But the trend is, and here it is, and the trend is is upward, and it's there even if you take out if you look at them without Harris County. So this slide shows the number of exonerations that have occurred, and the blue line shows with Harris County included. But if you follow the red line, you see even if you take those Harris County drug cases out, there is definitely an upward trend. And IOs, innocence organizations, have participated in 461 exonerations since 1989, including a record 54 in 2017. Okay, I'm not used to using a map. And in a record 16 of the 2017 exonerations, CIUs and IOs worked on the same case. So what does this tell us about how exonerations occur? In particular, what does the steadily increasing number of cases involving professional exonerators tell us? Well, at the most basic level, we see more exonerations where professional exonerators were involved because there's just more professional exonerators than there ever were before. But more importantly, their presence, the availability of these organizations, appears to be driving the increase in exonerations that we've seen over the years. And this graph shows us this. The number of exonerations without the assistance of a professional exonerator, the red line there, is pretty steady. I mean, there are fluctuations, but overall it's pretty steady. In contrast, if you look at the number of exonerations, the blue line, with the help of a professional exonerator, that has dramatically increased over time, particularly in the last 2 decades. Why is this interesting? Well, what it suggests is, and this really isn't all that surprising, is that the number of exonerations that we see is not so much a function of how many wrongful convictions there are, because we have no way to know how many there are, but rather a function of how many resources are available to innocent defendants. And I don't need to tell anybody in this room how hard it is, how difficult the path to exoneration is. It takes resources, expertise, and no small amount of luck for a wrongly convicted defendant to convince a court that they're innocent. And it's often something a defendant, particularly one who's incarcerated, can't do without the help of a well-resourced IO or the attention of a committed CIU. And this is especially true given that most exonerations, contrary to popular opinion, are not the result of DNA. DNA exonerations are hard enough to achieve. They require often extensive investigation to find old pieces of forensic evidence that's in some cardboard box tucked away in some police basement. But proving cases without DNA is even, well, it's exponentially harder. As IOs has expanded over time, more are willing to take cases that don't involve DNA. And we see more exonerations of all kinds, including those that are not based on DNA. And on this point of what is it that gets someone exonerated, Clara Stevens is going to talk a bit about it. But before I turn it over to her, I would like to close by, again, thanking everyone who made Housing the Registry here at the Newkirk Center possible. The work we do documenting exonerations is not especially glamorous, especially the counting part, which is what I'm talking about, nor is it sensational. In fact, we really do strive to be as objective, transparent, and thorough as possible. But we do it because we know that unless we are meticulous in paying attention and documenting each and every exoneration, from the most outrageous police misconduct that leads to a wrongful murder conviction to mundane bureaucratic indifference that produces a false conviction in a misdemeanor drug possession. We're in the dark, and that's what we're trying to do, is to remedy that. So thank you.
Before introducing the guest speaker, I just want to make a brief comment. Earlier,
Ron Huff described what I can only describe as an Orwellian experience as a judge stripped information from his credentials. Really, it is an Orwellian thing. It was like reading about a trial conducted in the era of Joseph Stalin. And in an era and at a time when vocabulary is very important, I would like to just mention one little bright light. Barbara O'Brien was just talking about something called conviction integrity units. I can assure you that at the time that Ron first started researching this, and even more recently, when I started writing about these cases somewhere in the 90s, there was no such thing as a conviction integrity unit. And organizations like Innocence Project and the Registry have had an impact on starting to change some of the vocabulary. So we can take some heart in that, because we have to take heart, or otherwise you could just get so depressed about this that you would become catatonic. Okay. There's an old saying in the world of charity, I gave it home. Clara Stevens gave it home. Before she became a research scholar here, she was a public defender in Miami, Florida. She came to us through the good graces of a donation from a very smart, committed woman, Denise Ferraro, whose husband, Frank Quattrone, was wrongfully convicted of a white-collar crime. Most of the wrongful convictions involve blue-collar crimes, but this was a white-collar crime, and fortunately, they then started to take this issue very, very seriously and got involved. So I would now like to bring up Clara, who's here courtesy of the Ferraro's donation.
So yeah, I'm Clara. I am the research scholar at the registry, so I'm one of two staff people, myself and Maury. And among a bunch of other things, I head up the research projects. I have two right now, and usually I have some law students that work with me, and some other research assistants, and all this could not be possible without UCI and the Newkirk Center. So I'm going to tell you a little bit about one of our projects that's in process. Oh, that's me, and that's my friend Desmond Ricks, who I will tell you about in a minute. And so I guess this goes without saying, I am going to talk about some cases, and they're really hard to listen to sometimes, so I just wanted to let you know that in advance. So this is Gary Dotson. He is popularly thought of as the first DNA exoneration in the US, although Maurice reminded me today that that's not entirely true. However, in 1979, a young woman who was worried that she had gotten pregnant by her boyfriend invented a rape and reported it to police. She scratched herself on her stomach, ripped her panties a little bit, and reported it to police. And they showed her a photo array and encouraged her to pick this guy, Gary Dotson. So he was convicted and went to jail based on her testimony. Now, there were a lot of other things going on in this case, but if I tell you every single piece of every single case I'm going to talk about, we would be here all day. So in 1985, she admitted she lied. She felt really guilty. She told her pastor. By then, she was married. And she just said, I'm having my come to Jesus moment, and I lied. But the prosecutors didn't believe her. They said, you're lying now, not in 1979. So they didn't do anything about it. But then in 1988, Gary got a lawyer who heard about this interesting new thing in England called DNA testing. So they DNA tested the panties that she had ripped, and they found that the DNA definitively excluded Gary and included her boyfriend at the time, thereby verifying her story that she had lied because of that. And so the registry starts in 1989 because these are the first DNA cases. We sort of had to pick a starting point, and our starting point is DNA cases. With those cases, the 2,224 cases as of today, we've been able to show what are some of the contributing factors to wrongful conviction. So, or in other words, how did we get from the crime to conviction. How did that happen if this person is innocent? So in Gary's case, you have the perjury, false accusation, that second one there, by the woman, and also there was some false and misleading forensic evidence presented in his trial. But until now, other than DNA, like in Gary's case, we didn't have systematic data on how the exonerations happen. So what happens between conviction and exoneration? How did we get there? How did we figure out that Gary is innocent? So with Gary, it's DNA, and we have had that information since we started. So, but as you can see here, these are all our exonerations by year. DNA is not the most common way of exonerating people, and not by a long shot. This is a common misconception. People think all these DNA exonerations are happening. Right now, we have, as I said, 2,224 exonerations in the registry, and only 471 have any DNA at all. And there are even less in which DNA is the primary basis for exoneration. So for example, DNA might say that somebody is not included in the DNA sample, but the DNA sample was not a big part of the initial conviction anyway. So most cases look a lot more like this. This is Frankie Carrillo. If you guys were here last year, you will have heard him speak. He tells his story much better than I'm about to, and again, I'm leaving out some details because we could be here all day. So in 1991, a man was killed in a drive-by shooting. His son and his son's friends were there. And after the cops identified Frankie as a suspect in a separate shooting that he didn't commit, they showed his picture to one of the friends who was present at this shooting. So subsequently, all 5 of the friends and the son of the victim identified Frankie in court, and he was convicted. In 2003, I mean, if you saw Frankie last year, you know he's a guy that doesn't just sit around. So he was looking through defense investigation files and all this stuff, and he found that shortly after his trial, a man had confessed to being the gunman in the case. And so Frankie presented this to the victim's son, and the victim's son said, well, it was my friend that told me that you did it. My friend said, Frankie did it, you have to identify him in court. So Frankie and the victim's son spoke to this friend, Scott, the one who had initially identified Frankie, and Scott said, well, when the cops showed me Frankie's picture, they said they had already figured out he did it, and they needed me to say that he did it. So all 5 of these friends who testified against him and the son, every single one of them recanted their testimonies. They all said it was not Frankie. And then, of course, we know who committed the crime, because that person had admitted to it shortly after Frankie's conviction. But Frankie still spent 20 years in prison. He was exonerated in 2011. So the question is, how often do each of these factors come up? Right? Frankie's case doesn't have any DNA. How do we know how often does somebody recant? How often is there new information of that kind? So that is what this project is about. This is kind of a simplified version of it. But we have coded about 400 cases in the registry so far. And you'll see DNA is, you know, not even in the top 4 or 5. We have other forensic evidence. We have other physical evidence, recantations, and then we have a huge amount of impeachment evidence. So what that means is that after conviction, we find out that one of the witnesses, whether it's an officer, whether it's the victim, whether it's the forensic examiner, whoever it is, we find out that there is somehow that they were not credible. So for example, in a victim impeachment case, we may find out that this same person has accused 5 people of the same thing before. And then we have a large one that is other witness information. So that'll be things like alibi evidence, somebody that we didn't know ahead of time or wasn't called because the lawyer was incompetent or whatever it is that had impeachment evidence. And then the last one is some type of evidence about an alternate suspect. So like in Frankie's case, a guy admitted to somebody else. In some cases, they confess to authorities. In some cases, we see an MO that keeps getting repeated. So for Frankie's case, as I said, we would have put in that somebody recanted. There's also impeachment evidence because the kids have said the cops told us to do this. And of course, the cops got on the stand and lied about it. They would never say on the stand, yeah, we told him who to pick. Whole case is done. So that's your impeachment evidence. And then we have the alternate suspect evidence. So in some cases, we only have one of those types of evidence. Brian Banks, who is also on our board, he is probably pretty well known around this area. He was a very promising football star when he was in high school, and a young woman accused him of raping her. There was no forensic evidence. There was nothing to convict him other than her word, and he was terrified. He was a kid. He was like 17, 18, and so he took a plea, and he ended up being 5 years in prison. He lost his football scholarship to USC, I believe it was, and didn't have his chance at the NFL. Many years later, she got back in touch with him and said, I know I lied. And he wore a wire, got her to admit it on tape, and that's the recantation. So why is this important? It's important because if you remember Gary Dotson, the recantation wasn't enough. They needed the DNA. But now that we know that these things happen often and people do recant in cases where somebody is innocent, people may be more likely to believe. In this case, David Gavitt from Michigan, he spent 25 years in prison for the murder of his wife and his 2 children via arson. And the way that we're tracking this is that he eventually was exonerated because our understanding of arson science has changed. So at the time, there were certain patterns in the house that fire investigators said, this means that he poured gasoline in the house because the fire couldn't possibly have burned this hot without gasoline in order to create this. We now know that that's just not true. And so he was exonerated based on this arson evidence, which again is something that we didn't track until now. Now we know. In how many cases has there been new interpretation of old evidence offered, new interpretation of old forensic evidence? And this is Des, who I said we'd get back to. The case against him was so flimsy. He was at a diner where a shooting occurred. He ran away because if a shooting occurs, are you going to stay there and hang out to see if there are more shooting? No, you're going to run. And on the way, he discarded his jacket. The police officers found it, went to his house, searched his house, and found his mother's gun, which was still in the house. Subsequently, quite a few things happened, and at trial, a woman identified him. After trial, the forensic examiner who had examined the bullets got in touch with Des because a woman this One Woman Innocence Project, Claudia Whitman, had contacted him, and he said, I always felt uncomfortable about your case because the bullets that I examined, which were supposedly from the dead person's body, were too pristine to have gone through a body. So I always felt uncomfortable about that. They matched your mom's gun, but it didn't feel right. And at the time, a few years later, the Detroit Crime Lab was found to have committed major misconduct. And if you fast forward, I guess for Des, it was not ever fast enough, obviously, we found out that, and by we, I say because I worked at the Michigan Innocence Clinic on his case, we found out that the Detroit Crime Lab had falsified his bullet evidence. So they took his mother's gun, fired it, and passed it off as the bullets that came from the body, which they later determined could not have been possible. So this, again, would be something that we would not have tracked before, but now we do. And this hopefully will help people realize, when we first brought this case to the clinic, one of the clinic supervisors goes, "This is the most far-fetched thing I have ever heard. There's no way that this is possible," but it was. And that's the kind of thing that we're trying to track now, so we have more information about how these exonerations occur. And that is what we're doing that UCI has made possible for us. Thank you.
Thank you, Clara. For those of you who are interested in further exploring the subject of how the forensic science related to fire has evolved, I suggest that you Google an article in the New Yorker about a man named Willingham in Texas, who was executed, and there's a significant amount of evidence that the fire evidence that was presented against him at the time was wrong, and he is, I think, could be accurately described as a dead, innocent person. If you turn on your television at almost any hour of the day or night, on almost any channel, you can see some sort of a drama or quote-unquote reality show about prosecutors doing something wonderful. There's not a lot of alternative in the media. There's a growing amount, though, there's a growing amount, but not, and that's particularly important. So I want to bring forth Kelly Loudenberg as a filmmaker and artist who's been exploring the justice system for more than a decade, most recently through her The Confession Tapes, a Netflix series that she created and directed. This was based on work that she had done originally writing for publications like The Atlantic and The New York Times. Kelly, please come forward.
Hello. So the show came out in September, and I had to kind of step away from some of these cases because it was so upsetting, and I was just so involved for so long, and I had to find a way to kind of let it go a little bit. So I'm gonna show you a clip from the third episode. It's called A Public Apology, and I just talk a little bit about my process making the show and why that was a good case for the show. So the idea for the show came when I was watching an episode of Forensic Files, which I have now learned not to trust at all. And there was a false confession involved. And I was just like, wow. And this is before Making a Murder came out. I think maybe Serial had just come out and I hadn't listened to it. I wasn't into this like true crime stuff. I sometimes watched Forensic Files because of some of the human stories I would find. As a filmmaker, I was interested in those. But I wasn't like making that kind of work. I was making work about like urban design and architecture. But then I saw that and I was like, that's really interesting. And I contacted Steve Drizzen at the Center on Wrongful Convictions because he was an expert in false confessions. And this is sort of pre-Making a Murder. I started doing research on that. Steve gave me a bunch of academic articles to read, books to read, and then cases to look into. And I just really started digging into it as much as I could and kind of realized that there was a big picture here that I hadn't really seen anyone addressing like in like a mass popular media. So I thought, why don't I make a series that kind of tells a picture that kind of tells a comprehensive picture of a number of cases that are kind of still active, still ongoing. So these cases are not exonerations, unfortunately. So I kind of went from there, and I spent about a year researching it and just reaching out to people and figuring out which cases would kind of fit this tapestry that I was trying to describe. And actually I want to thank the registry because it was instrumental in our research, and even a lot of people at this university helped us too in giving us direction and guidance and support and just sharing with us their knowledge so that we could be informed as we went about making this show. So what else do I want to say about this? The part of the reason I loved the registry was that it showed us that we were on the right track. It showed us where the patterns were, and we were wanting to make sure that we could address what those patterns were, and that each episode might even address a different, an extra problem in addition to a false confession. So there was some episodes that addressed junk science, some that addressed plea deals, ineffective counsel. There were all kinds of cases. We talked to jurors. We really tried to understand the problem on a systemic level. So I can pull up this clip. I'm just going to take it right off Netflix. But this case, the Wesley Myers case, was out of Charleston, South Carolina. I think I heard about this one from either Richard Leo or Steve Drizzen. We consulted with a few different false confession experts who advised us on what cases we might want to look into. And from there, we really had a hell of a time getting materials, FOIA-ing and whatnot, and really just trying to figure out like which cases would fit into this tapestry that we were trying to describe. And Wesley's case fit for a lot of reasons, and the reason I like this case so much is that Wesley was out. His conviction had been overturned, but he was waiting to see if he would be retried. And he had been waiting at that point. I mean, we made it over the course of about a year. And it had been about 2 years when we were, kind of wrapping up his story. And then I heard that they were actually going to retry him if he didn't sign a plea deal. So that sent me into like a very depressed spiral, but I went to his plea hearing, and this was already turned in, so we couldn't alter the ending. But it enlightened me even further to how it works. We never did get that video of that interrogation, although I would have loved to have seen that. The tape that you saw at the very beginning of that clip was actually discovered later. It came kind of slipped up that how they found it, but it basically was from a tissue box camera. And so nobody really knew how coercive that interrogation was. That was just the sort of the prep for the next day, which he was still in like such a state of shock. It's unbelievable that they would even interrogate him like this. But I mean, it later came back that they used microscopic hair analysis, which we know is really unreliable. They lied to him about the evidence, which I didn't know you could do until I started making this show. There was arson science. It was I don't even want to go into the details of the case, but they did a perp walk with him, so he confessed on TV, which was a very hard confession to come back from. So it was just very hard to believe that someone would go out and confess on camera. But later they found out that hair didn't match him. None of the DNA evidence matched him either. So that's what got his conviction overturned. But in the end, the prosecution bullied him into signing a plea. So when we met up with him, he was actually on house arrest on an apple orchard in North Carolina, and he had found a new girlfriend and was doing okay. Now he's a granddad, and he's trying to move on, but I think he's a bit bitter about his plea, which I don't blame him. But yeah, so we wanted to kind of try to show like the systemic problems through false confessions, and the show came out and it was really well received on Netflix, and yeah, I'm really happy about that. I think I covered everything. I'm just thankful for institutions like the registry for all the context and research and guidance they provided us, and we're going to continue to tell these stories and try to appeal to a mass audience to help them understand what these problems are. And I know that they're now like screening this in law schools and universities and high schools, so I'm really glad that it's also a teaching tool, which was sort of an unintended thing that happened that I'm excited about. And I'm not really allowed to talk about our new projects, but We're doing a few new shows with Netflix, so, and one of them is going to be more junk science focused, so hope to.
Hair, fingerprints, dog bite marks. There are so many flaws in forensic science, and you can read about a number of the cases involving all of those forensic problems on the registry website. I would particularly draw your attention to another hair case of a man named Charles Fain in Idaho who did 17 years for a murder he didn't commit. I'm familiar with that one because I wrote about it. It gives me a great deal of not just personal but professional pleasure to introduce the next speaker, Maury Posley. When I first started covering legal stuff in 1989, a friend of mine who I'd been on a labor beat with said, "You got to call Maury Posley." So Maury Posley is part of the trio of Chicago Tribune reporters who did groundbreaking work on wrongful convictions in Illinois, which led to changes in state laws. It led the governor to commute the sentences of, I believe it was 154 people. They also, drew attention to the significant systemic problems in the capital punishment system in Texas and Florida, among other places. Maury also worked on a Pulitzer Prize-winning series on an entirely different topic. Not to sound overly flippant, but Maury is at UCI for basically the same reason I am, courtesy of a rapacious capitalist, Sam Zell, who bought a newspaper chain that included Maury's newspaper and mine, and basically made it clear that he was not interested in having people like us around. So I'd like to bring Maury to the stage.
We tell stories in a couple different ways, although primarily we write the stories. One of the ways we do them is through graphics. Clara created this on the website, and it's a list of, you might call it a wall of shame, but it's the list of the longest incarcerations of someone who's been exonerated. And you know, it's a cliche to say that a picture tells 1,000 words, but Richard Phillips spent 45 years and 2 months in prison for a crime that he did not commit, and here he is being exonerated at the age of 71. You can see that list on there, and it's just sort of amazing to see how many years just the top 20 people spent alone. So we have, we've talked a lot about tonight, you've heard a lot about these summaries. Every summary essentially tells a similar story. They range in lengths from 250 to 2,500 words, depending upon the complexity, the length of time that it took to unravel the case, the number of factors that had to come into play to cause the prosecution or judges to believe that in fact this person was wrongly convicted. But they sort of follow the same arc of there's a crime, and then there's an arrest, and then someone who's arrested is tried and convicted, and then they appeal, sometimes for decades, and ultimately it's a story of an exoneration. That's why they're in the registry. I just want to tell you about one. So I've been with the registry since it went public. I've written about 1,600 of the 2,200 summaries in there. I can't remember them all now. Sometimes I see a news story and I think, gee, that's a case we don't know about. And sure enough, I Google National Registry and the person's name, and yes, and in fact, I wrote it. I'm not sure exactly what that's a function of. I'd like to think it's a function of just lots of information and not old age. There's a case that And some cases are more remarkable than others. And there's a case that happened in California that I wanted to tell you about. It starts back in November of 1991 when a 42-year-old man named Vicente Benavides and his girlfriend Estella brought Estella's 21-month-old daughter into a hospital in Kern County, California. They said her name was Consuelo. And they said that they thought she might have run into a door chasing her 9-year-old sister, Christina. 9 days and 2 hospitals later, Consuelo died. Now, this would seemingly be sort of this very sad end to a tragic accident, but not for Vicente. Essentially, a cascade of medical errors fueled by substantial and egregious prosecutorial misconduct and police misconduct turned this typical childhood accident into a crime of horrific proportion. Vicente, who was later determined to essentially have the mental capacity of about a 7 or 8-year-old, was accused of raping this 21-month-old girl to death. And I won't go into all the details. The summary is in your handouts. It's on the website. But 18 months later, in April of 1993, a jury convicted him of first-degree murder, rape, sodomy, lewd conduct, and the testimony at the trial was extraordinarily graphic. The verdict was swift. 2 days later, he was sentenced to death. And so off he went to San Quentin, the home of California's death row, which is the largest death row of any state in the US now, with about 750 people. 12 years later, in 2005, the California Supreme Court upheld his conviction. By that time, lawyers at the Habeas Corpus Resource Center in San Francisco had been reinvestigating his case. It's a long process in California. Some people have been on death row here for nearly 40 years. But then in March of this year, something remarkable happened. The California Supreme Court vacated Vicente's convictions based on evidence presented by his lawyers, most notably the woman in this photo, Christina Bourdet. This is him on the day he was released, April 19, 2018. The new evidence consisted of testimony from numerous medical experts that the testimony at the trial was wrong. They were joined by about 10 or so of the prosecution's trial experts who admitted that their trial testimony was wrong as well. These experts concluded, and the Supreme Court agreed, that the evidence that was presented to show that she died from this horrible rape actually was the result of the treatment efforts by the physicians at the hospitals. The medical treatment that created the evidence that was erroneously characterized at the trial as proof that he had committed this horrible crime. Dr. Drace, I just want to quote one thing. Dr. Tracy Corey, who was a forensic pathologist who reviewed the evidence, particularly the original autopsy that was done in Kern County, said that she was embarrassed about the pathologist because what he said isn't even anatomically possible. She said, "I'm embarrassed that a pathologist didn't know better, didn't know anatomy better. But a lot of people didn't know better. It wasn't him alone. It was a whole bunch of people made a bad, bad bunch of mistakes." But so Vicente is free. So, you know, all of these stories that we tell, each one is a miracle or a tragedy, however you want to characterize it. But each one in its individual self points to a larger truth about the criminal justice system, and each one of these truths provides a collective power to change that reaches beyond each one of these individual moments in time. You know, I want to particularly thank the Newkirks, Martha and Jim, and the Newkirk Center and UCI for really continuing to breathe life into the registry, because I believe it does have the power to change. I believe, from my perspective, that is perhaps one of the most significant develops in the century in the criminal justice system, in the sense that we have data, because we count things, and we have stories that are true. Thank you.
So one of the things that we do here at UCI with the registry that wasn't done before is use it for undergraduate student learning. So since the registry started at UCI, Maurice and I have transformed the Miscarriages of Justice course in Criminology, Law, and Society, which was a great course when Ron and I and Richard Leo taught it, in just telling people about the problems of wrongful convictions, into a course in which we have the students go through the process of looking for exonerations and working through the whole process of a case, from searching for the case, coding the case, and then even writing a summary like Maurice writes. So we've taught the course now 3 times to 219 students, and then some of those students continue and take independent study with us to work more intensively in a smaller group looking for cases. And then some of those students at UCI, you've heard of teaching assistants. We also have learning assistants, which are undergraduate students who then come back into a course and teach other students that. And if you talk to education professionals, the best way to learn something is to teach it to somebody else. So the first 2 learning assistants were Natalie Nunez and Sarah Wilkinson, who couldn't be here, who then went back and were learning assistants in the course this year. So we're hoping to feed those students back, kind of like sourdough starter, back into the course to teach other students. So these are some of the skills that we think the students can get from working on registry cases in this course. And just a report on what we've done. We did a couple states to start off, and then we decided to kind of blanket Indiana. So starting in spring 2017, Maurice and I started with 1,000 Indiana cases with appellate decisions ranging from 1984 until 2017. And the students plowed through those 1,000 cases and found so far a total of 11 previously unknown exonerations that we would not have known about had we not gone through these cases. And that's 30% of all the known Indiana exonerations in the registry. So that tells you something. I'm not quite sure what, but it tells you something. It's a little bit like the drunk looking under the street light for their keys, that the exonerations are where you look for them. So by blanketing this state, we found a lot more exonerations. Equally important, we eliminated 989 cases that were not exonerations. So I wanted to so in the independent study class, in addition to the students you'll hear from, Yvette Garcia, Nora Ocampo, and Elena Hernandez worked with us on these cases. The year before, Wendy Moreno, who I see here, worked with us on independent study. She found the Larry Fox case, no, one of, Donald Wilson case from Indiana. So I wanted to let some of the students talk about some of their experiences. Kevin McKinnon came to my office and said he wanted to study wrongful convictions, and I said, you need to take this class first, which he did, and I said, we'll see how this Kevin pans out. But he really distinguished himself in the seriousness with which he applied himself to mastering the material. He's now doing an independent research project through the UCI's Undergraduate Research Opportunity Program, and he's written up with Maurice 2 cases, one of which, the DeMott case, is outside as a handout. So, Kevin.
Thank you, Dr. Cole and the National Registry of Exonerations for having Natalie, Jordan, and me speak on behalf of the learning experiences of undergraduate students working with the National Registry of Exonerations in the classroom environment. I personally have been in 3 different classes that we've either used National Registry of Exoneration resources or have worked with the National Registry of Exonerations. The first is the Miscarriages of Justice class that Dr. Cole mentioned. This is a really great overview class looking at what is an exoneration, as well as different factors that lead to exonerations, as well as wrongful convictions and the differences between those. This is also a really awesome introductory experience in a group environment, as students are able to work in groups of about 5 to 8 students, looking for potential exonerations. We're able to grow our skills looking through Westlaw and contacting different legal officials like court clerks and attorneys and interviewing them in that process. The second class that I've been in is as a research assistant for the National Registry of Exonerations. This has been awesome because it's been a more in-depth experience, and it's given us the opportunity to take individual responsibility and ownership of our specific case. That includes starting from the beginning of taking this case and looking at Westlaw, all the way through to the end of the case, which includes coding and writing the narrative for the publication on the website of that specific exoneration. Personally, I just completed my first exoneration with the help of Mr. Posley, helping writing the narrative on that, and that was my first opportunity to code something for the National Registry of Exonerations, which was a really rich and fruitful experience, as well as my first time being able to request documentation from an appellate court and read through different court transcripts as well as different court briefs. The third class that I have been using resources from the National Registry of Exonerations is as an independent undergraduate research project where I was able to read through the National Registry of Exoneration cases as well as the scholarly and research articles from Mr. Posley, Dr. Gross, as well as Dr. Cole. I was able to form a proposal which is looking into some things related to official misconduct as it pertains to exonerations and wrongful convictions, and not only builds my skills through these 3 classes in investigatory skills, looking in the legal procedures, but also as a researcher, someone who hopes to pursue academia and research one day. So, thank you.
So in this class, whether there's 100 students or 50 students, we have them all write a narrative of, like Maurice writes, of the same case. And then we tell them the best one will get to co-write it with Maurice. So as I read through them, I thought, who's this Natalie Nunez? She can really write, but she never speaks in class. And she's been working with me for a while now, and then she did study abroad, and she's going to Portland State to study criminology next year. So, Natalie.
So, hi. My name is Natalie, obviously. I had the opportunity to participate with the registry as an undergrad at UCI. But unfortunately, it's going to come to an end after the spring. So after taking Professor Cole's Miscarriages of Justice Upper Division Criminology course, I went on to participate as a researcher in 198, Director Studies with Professor Cole. along with other undergraduate students. And working alongside Professor Cole and Maurice Bosley, I was able to strengthen my research, coding, and writing skills, as Professor Cole mentioned. But furthermore, I feel I was able to strengthen my interpersonal skills, organizational skills, and overall communication skills. And as students, I think we were able to work individually, but also collectively towards one goal, and that's to find exonerations and just try to further look into them and why they're so important to study. And I think it taught us all, if I speak for everyone, it taught us all about self-discipline, and we had to build a very strong work ethic as a result. And through the various emails, multiple emails, confusing dockets and case files and phone calls with attorneys and conversations with grumpy court clerks in the morning, we all basically were able to build these skills, and it was something that I think we all appreciate and that we learned as undergraduates, because that's what college is for, I guess. So we were really able to get the most out of this experience. And then, as Professor Cole mentioned earlier this year, I returned as a learning assistant for the Miscarriages of Justice course. And being an assistant really allowed me to engage and share what I have learned with other students, and I found it really rewarding. And like Professor Cole mentioned before, it really is true. I found it to be true that the best way to learn is to really be able to teach it to somebody else. Like, it was a test of knowledge, I guess. If you really know something, you would be able to explain it to somebody else. And ultimately, my involvement with the registry, it emphasized, for me at least, the importance of continuing the study of criminology and crime. Social injustices, such as obviously these revealed by the registry, displayed how understanding crime and criminology really is important for implementation and execution of criminal justice and social policies. And I believe all of this serves as an effort to better an imperfect criminology or U.S. criminal justice system. And just to wrap up, lastly, I would just like to say that I'm thankful for this experience, and I strongly encourage other undergraduate students to take advantage of the opportunities that the registry provides for us. It is because of experiences at UCI, that, like the registry, that I decided I wanted to continue my studies and go on to graduate school and continue to study criminology. So I would like to thank Professor Cole and Maurice and really anybody who is involved in this project, because it really, I find it very, very rewarding and important. So thank you.
So as I mentioned, we have everyone in the class write one case. And this year, the student we chose to do the co-write the official registry entry with Maurice on the Stephen Everling case, which is a handout outside, was Jordan Facey. Narrowly, Kevin wrote a good one too, but Jordan's was the best. Jordan is a senior criminology law and society major, and she's planning to go to law school.
Good evening, my name is Jordan, and I'm currently enrolled in independent study with Professor Cole. I originally started working on exonerations when I was enrolled in Miscarriages of Justices. In that class, we learned about different exonerations, along with the contributing factors that can lead to an exoneration. This class was mainly made up of researching cases by looking at case dockets, contacting clerks, as Natalie told you guys about, and speaking with attorneys. If we found an exoneration, then we worked on coding, which helped us look at different aspects of the case from qualitative data. From there, we wrote narratives for the exoneree. These narratives allow readers to find more information about what happened throughout the case and the circumstances that led to the exoneration. I fortunately had the opportunity to work on the Stephen Everling case with Maurice, which is now published in the National Registry of Exonerations. This provided me with a great opportunity to learn how to read through case dockets and piece together a narrative for Mr. Everling. After taking miscarriages of justices, I was invited to work on exoneration cases for independent study. Our independent study is similar to the class, except for instead of working with groups, we're working on our own. So just imagine trying to keep yourself going, making sure that you're turning things in on time by yourself. Independent study has aided me in learning since I have been reading through dockets to find more important elements that have helped me develop important skills such as speaking to clerks and attorneys to learn more information about the cases that can lead to an exoneration. This was a challenge for many of us in the beginning since we weren't used to some of the legal jargon and we were trying to remember who we needed to contact and what we needed to request from them, and our generation is not really that great with speaking on the phone, as you guys know. This class, my independent study, and my work on the narrative have played an important role in my future law school trajectory. I have received a lot of hands-on experience, which is not common for many undergrads. It has also allowed me to work more closely with Professor Cole. This is important for undergrads since it's good to have a mentor to come to when it comes to applying to law school, grad school, or if you just have any situations you need to speak to. I can also use what I have learned along with the work that I have done to understand how to properly read dockets and communicate with people in the legal profession. It has also solidified my goal to become an attorney that does work in this field. I feel that this work is important to continue since there are many people in the system that have been wrongfully convicted of crimes. Many of these people need a voice, someone to believe in them, and mainly assistance in order to help their cases be heard. It is also important to minimize and hopefully eliminate the amount of innocent people that are being convicted for other people's crimes. So thank you, Maurice and Professor Cole, for everything.
We are going to change the format for the last part of the program. Can you hear? I know you can hear me because I'm loud. Before starting this, I would like to also thank the Newkirks not only for what they've done here, but they did something else wonderful here, at least from my point of view. I'm a huge baseball fan, and I'm very grateful to the Newkirks for the wonderful baseball stadium that they brought this campus, which gives me many hours of joy. So thank you for that as well. Our next, I'm going to have a conversation with Bruce Lisker. Bruce Lisker I first found out about Bruce Lisker. I was sitting next to a couple of guys who I worked with at the LA Times, Matt Late and Scott Glover, and they were working on Bruce's case for many months. They were researching it, and as some of you may know, when the police department or prosecutors put together a case, they have a huge loose-leaf notebook of evidence that they're gathering up that's called a murder book. And as this process was going on with Scott and Matt, they were compiling a loose-leaf notebook that was even larger than the normal murder book because they were deconstructing what had happened in Bruce's case. Now, Bruce was spent 24 years in prison for murdering his mother, a crime he did not commit. It happened in the San Fernando Valley, only about a 15-minute drive from where I grew up many, many years ago, since I'm probably the oldest person in the room. Earlier today, Clara put up on the board a chart with factors that seem to be in these cases. I want to quickly mention the factors. There's DNA, there's forensic evidence, physical evidence, impeachment evidence, witness information, alternative suspect. 5 of those things, everything except DNA, was involved in Bruce's case. In addition to that, I should also mention that there are, from my point of view, that there were 3 other things that are like really important in Bruce's case. There's rampant police misconduct. There's also, at a certain point, a false confession. And then, maybe the grandest thing of all, there's something called tunnel vision. I'm sure that a lot of you are familiar with something called confirmation bias. People start thinking one way, and then they get stuck. And so I call it tunnel vision. So I would like to have a conversation with Bruce about some of what went on in his case. And I guess the first thing is, what do you think was the most significant reason that you got convicted in the first place?
I need the microphone. Well, as you said, police lock in and they lock out. And statistically speaking, when a 66-year-old woman with no known enemies is murdered in her own home and her son finds her, they're going to look at the son. They're going to look at, starting the closest relationship and moving outward until they find somebody that they can, for lack of a better term, pin it on. And that's not to be cynical, that's just they're trying to assign a case to a perpetrator. And what's the largest? I would say probably the jailhouse informant was most pivotal in causing my wrongful conviction, in the sense that, sorry.
Well, I was just going to say, jailhouse informants are very important in a lot of these cases. A jailhouse informant was very important in Bruce's case. In fact, the problem with jailhouse informants was so rampant in Los Angeles. At the time of Bruce's case, the two jailhouse informant fabricators came forward and were rejected by the authorities before one by the name of Robert Hughes came forward, who they decided to believe. Why don't you tell everybody about what happened with Robert Hughes?
So just a few days after the juvenile court ordered that I stay in Sylmar Juvenile Hall pending completion of the proceedings, I was taken in the dark of night by van and placed in the LA County Jail. Over a court order, and I was placed in a cell. As a juvenile, there's a statute that protects you. You're not to be exposed to adult inmates at all, even momentarily, but I was placed alone, 17 years old, in a cell that had holes in the walls, and 4 canine classified, that's known informants that are there for ostensibly their own protection, but really to set up other people as well. Inmates occupying these cells surrounding mine, and these first 2 had approached me and began conversation. They were kind of clumsy as far as informants go, and so it became a weird feeling situation to me. And then, so I just stopped talking to them. I became kind of frightened of them and scared of them. And then this guy on the other side, who was much more seasoned, I was the 4th person he ultimately came forward claiming a confession from in the span of 18 months, started talking to me much more subdued, much more helpful, or at least it seemed to me. He offered to help me with his case. He said he'd been in and out of the criminal justice system. He was late 20s, I think, but he was born again, and so he was a good guy now, and he offered to help me with my case. Ultimately, I rolled up my police reports that I had in my possession and shoved them through the hole in the wall, and he said he would take a look at them and give me any pointers he could.
Just think about this, a hole in a wall in a jail cell. Something that you might be concerned about, that maybe people would be passing weapons back and forth, but they weren't concerned about weapons being passed and forth. They wanted to basically have you give information so that he could then construct a story, right? That's correct. The scandal that you mentioned about the jailhouse informant use, in the criminal justice system actually was the basis of the LA County grand jury being convened in 1989 and writing just a bombshell 150-page report that detailed how prosecutors and jailers and police had this unholy alliance where if the evidence was lacking in a high-profile case, you would suddenly find yourself in the snitch tank. And you're like, I'm not a snitch. Just, you can't argue with them. They're putting you in a cell. And these people would immediately start getting at you and trying to, glean information from you that they could piece together. And here I walked right into it by handing him my police report. So he wrote down key facts from the police reports, which the prosecutor then presented to the jury as material only the killer could possibly know, or somebody who had read the police reports. And he omitted that part. And that, I think, was the most compelling evidence against me. The other part was also police. There was a detective named Monsu, who it was one of his first homicide cases. He was assigned this case, and he came to our house, and I had come to the house and had to look through the window, and I saw my mother inside, and broke in and called 911. I don't think they had 911. He said, systematically, everything that I told him, he said was a lie. He said, I went out there. I couldn't see in the window. It was a bright sunny day. The reflection on the glass created a glare that prevented the view. And
furthermore, these bloody footprints that were found inside the house, he then later testified, quite closely resembled my soles of my tennis shoes. It was never submitted for footwear analysis. He just testified that it quite closely resembled, which would probably lead to a logical question, why didn't your attorney do something about that in trial? The other big thing that led to my wrongful conviction was the fact that I had the worst attorney. He basically, at the point when Robert Hughes, the informant, came in and he brought the tape down and played it for me in juvenile hall, he stopped working. I saw it in his eyes. He checked out. He was not my attorney anymore. He was just phoning it in. And he didn't do some basic stuff, rudimentary stuff.
One of the most shocking things about the Rampart scandal that occurred not in the same general era as yours was that there were a number of lawyers who had represented defendants, who it sounds like were like your lawyer, who were basically kind of burnt out. And that although they sort of basically, as a defense lawyer, you have, basically a blood oath to do vigorous advocacy for your client, not all of them do vigorous advocacy, and you certainly had a person like that. And as I recall, when the LA Times did their first big expose on this case in 2005, he declined to speak to them. Now, you later got a great lawyer, Bill Janago, who unfortunately is no longer living, who did your habeas. But I think there's something else I want to jump into, because I know we don't have a lot of time. You, as I recall, went to, I think, 3 high schools in the LA area. I don't believe, at least at the time that you were accused, you were 17, you had not been to college, you then went to prison for a long time. And basically, while you were in prison, you played an instrumental role in what led to your ultimate exoneration, because you triangulated some information that other people had not paid attention to. Could you tell the people a bit about the information you triangulated while you were in prison?
Yeah, I think it's quite similar to the compiling and coding the information for the exoneration database. I gathered all the police reports and any scrap of paper. My father, who was always on my side and stayed by my side until his passing in '95, kept everything, kept all my trial transcripts, everything. I had them all sent in to me as soon as I could get them. And I went through line by line every single document, every single transcript. And Detective Monsu wrote X in his police report. He then testified at my Dennis H. juvenile detention hearing a little bit different. And then in my prelim, quite a bit different. And then by trial, he was saying something else, because each hearing was aimed to do a certain thing, And I documented it, and I wrote it down. And I had, when I was done with it, about a 60-page document, typewritten, single-spaced, with over 700 footnotes, because nobody's going to believe a prisoner unless you document everything. And so I compiled this document that I was able then to send to investigators and lawyers, and I had 4 sets of lawyers by the time I got to my really good attorney, Bill Janago. And yeah, that really, that was what I did. And because you have, the one asset that you have on, in there is time. You have an abundance of time. And so I'd use every opportunity to do that.
Now, one of the things that seemed to be ignored in your case, and this sort of goes to the tunnel vision aspect, is one of the factors that Clara listed, alternate suspect. And there was a clear alternate suspect in this case that was ignored. And could you talk a little bit about the alternate suspect and then the evidence that you basically unearthed later on?
Absolutely. So about 2 weeks into my imprisonment, which lasted ultimately 26 years, in Sylmar Juvenile Hall, my dad and I, sitting in the visitation room, figured out that, because people were coming to him and saying that this Mike Ryan character had disappeared from LA after returning to LA from Mississippi 5 days prior to the murder. The day of, he's in the wind, and nobody's seen him since.
And was at your house the day before?
Was at the house the day before. My mom that night told my dad that he had been there looking for money and work he could do, and she sent him on his way. She didn't have anything to do. And the more I reflected on it, the more I initially told my dad no. When he mentioned his name, I was like, that's crazy. He wouldn't, And then the more I thought about it, he was a violent guy. He would try to solve every disagreement with violence, threats of violence. If you didn't go his way, he'd want to kick your ass. And so we basically solved the crime. He was obsessed with knives, and he disappeared. And so I wrote a letter to Detective Monsu, who had arrested me, He went out, he interviewed him. His story is so full of holes, it's just obviously, you know, he's obviously covering. He tried to say that he was checking into a Hollywood motel 12 miles away at approximately the time of the crime, 11 a.m., before he was told what the time of the crime was. And so he's like trying to volunteer, you know, an alibi. He said he'd gotten in a knife fight with some black guy, trying to pre-explain any blood that might have been on him that day. He didn't know if there were witnesses that, you know, saw him after the murder. And then he's suddenly in Mississippi. Well, Detective Monsue found him, went out to talk to him. He was already in custody for trying to rob or burgle another woman. And again, that story was so full of holes. So, like, we essentially knew.
And then, though, he went to check to see if the guy had a record, and he put in the wrong birth date so that it showed that he had no record, when in fact he did have a record,
yeah,
right?
no record came back. And
so the police work was sloppy.
So sloppy.
And now, the other thing is that there was another of the mysteries in this case was that your mother, Dora, had money in her wallet. And when the police came to the crime scene, the money was gone. Mm-hmm. And you didn't have the money. So if you had killed her, one of the logical things would be that you would have had the money, but you didn't have the money. The money was not found. Yeah. So I think it's important that years later, when Bruce was, you know, had been in several prisons and was, you know, potentially coming up to, you know, be on parole, probation, that something happened with regard to the money and the state parole board. Why don't you tell them about that? This is remarkable.
So inexplicably, Detective Monsue, so every time you come up to a parole board hearing, the police department that arrested you and the prosecutor's office that prosecuted you are solicited for their opinion as to whether or not you'd be a good risk for parole. And every time, of course, they say, no, horrible risk, denying parole. But Detective Monsue would write those letters. And in all the letters before, he made no mention of this. But then suddenly in this one letter, and I forget the exact year, but it was well on, he writes that years after the murder occurred, subsequent owners of the house had contacted me and reported that they found $150 in the attic above Bruce Lisker's old bedroom, thus confirming our original theory of the crime. Don't listen to him, he's saying, don't listen to that. And I read this because we have a right to examine everything in our central file before we go to board. I found it the next board hearing, because he sent it too late for the previous one. And I immediately said, this is absolute fabrication. This can't be. Mike Ryan didn't stop. Go out to the garage, get a ladder, climb up in our attic, and go over my bedroom and stash the money before he, you know, fled. And so I had a private investigator working for me at the time who tracked down did a deed search, got all the subsequent owners, interviewed every last one of them. To a person, no, of course, we didn't find any money. And so that was a big part in proving that I was wrongly convicted. And so ironically, in a way, Detective Monsue stole my freedom, and then years later, because of his own arrogance, like handed me the keys to my cell, which still blows me away.
It's really extraordinary. Now, the basic, let's go back to the first thing. So you come there, you see through a window, it's the house where you grew up, so you don't want to break the window, you don't want to break in, but it turned out that this house, like a lot of houses in the valley at the time, had what are called louvered windows. I don't know if you're familiar with them. There's a crank. So you took the slats out, and you went in that way, and that was how you saw the body close up. But they said that this story didn't make any sense because anybody who had seen his mother would have just broken through the window. That would have smashed through the window. Yeah. And so what did your defense lawyer say about that?
He did. So one of the good things that he did do is he said, because the police said, well, first of all, it was a setup that he set the window up after killing his mother. And so he went, well, there's no blood on anything anywhere around here, and there was blood on his hands, right? Yes, there was. So no theory works, right? Because they're fabricating a case. But it points up the fact that I kind of want to maybe diverge a little bit.
Please do.
So in a movie that I was recently in that just came out called Survivor's Guide to Prison, one of the main pieces of advice is don't talk to police. And it sounds so cynical and it sounds so horrible because, I mean, I was a Boy Scout when I was a little kid. You know, I wasn't an angel, but I was, for a time, and we're trained when the, pardon my expression, shit hits the fan, you can call the police. That's what they're there for. And in a case like this, where statistically it's more likely a family member, they're already looking at me. So every single word that I spoke was another word that they could point at and try to make into a discrepancy with the facts that they observed at the case or they claimed to. And that's exactly what happens. And so, yeah.
I see that I've already run over our allotted time, so I'm just going to ask you one. No, it's me. Don't blame yourself. You're innocent. Okay. As my late wife used to say, you're the guilty party. I want to just ask you one thing that I think is really important when people think about these kind of cases. Could you, and I'm sorry if this is wrenching, but could you talk a little bit about how do you keep body and soul together for 24 years, you know, when they said you've committed the most heinous crime against a family member?
When something like this happens to you, it crushes you. It shocks you at first that they could even, first of all, I'm in shock and I'm starting the grieving process, which they interrupt with an accusation that I did. So you're shocked. And then that turns into just bewilderment and a bit of anger. And it, ultimately what it does over the course of decades is it crushes your spirit. You cease to feel at a visceral level that you have a right to not be wrongly imprisoned, a right to not be wrongly accused. And then you stop even having that little bit of thought process, and you just feel like somebody who's less than, and you're not entitled, and you're just, why would you even expect it? So, and that will generate some rage, some anger, a lot of energy, and I poured that back into surviving because, you know, pardon my allusion, but F them, they're not going to win. I'm not going to go out like this. They're not going to kill me with a weapon of prison. And so that kept my spirit going to a large degree. Having my dad, he was a pillar. He was you know, a Marine in World War II. He was an amazing human being, and he stuck by me 100%. Absent that, I don't know if I would have made it to that point to start being able to work on my own case and find my way in there. But you live in the margins, and it's folks who fight against wrongful convictions and who document it, and I'm so thankful to the NRE and to all of you and to everybody that you do what you do, because it's so vital. There are thousands of people still inside who haven't had the good fortune, if it sounds ironic that I say I have good fortune. It's such a minuscule percentage of people who petition for habeas corpus that get it. There are so many ways that it could have failed along the way as well. If I didn't have the means to hire attorneys, now there are more innocence projects. Back then there were not. Just thank you for doing what you're doing, and it's saved my life, you know.
Well, I'd just like to say it's just really wonderful that Bruce is out. He's a whole person. He's created a career, and I can say that a couple of years ago, I'm sort of like Maury, old school. I am not exactly the world's greatest with a computer, and Bruce came to my house and helped me with a computer problem, for which I paid him, which he richly deserves. So thank all the participants and the Newkirk.
Time for a couple questions.
Oh, questions? Questions? Yes.
Hi, I have a question. I'm Nancy Haig, and I am a defense attorney. I am just so overwhelmed, and I think I mentioned before, Mike, actually. But I'm so overwhelmed with the work that you do and how much information you bring to the game that the average person does not know, has no sense of at all. So my question is, what can we do with all this information to affect policy, to change policy so these holes in the system, egregious holes, you know, official misconduct, for example. What can we do with this information to affect that type of policy?
Well, I'm just going to make one suggestion, and then I'll let people more learned than me. One of the things you can do is urge your state legislator to support State Bill 923, which will require police throughout the state to adhere to evidence-based standards during eyewitness identifications. A very important bill that's now pending. Other thoughts?
I actually think that we should change the fact that there's no post-conviction discovery. Because one of the things that delayed my release for the better part of 10 years was the fact that we had no access to the murder book, the actual murder book. I kept a lot of paperwork, and a lot of people don't. But having access to the, to the nut of it is vital. We can't let that. I don't actually understand the logic behind it. I mean, finality of conviction and the finality of the jury verdict, I think, is what they're aiming at. But it's causing innocent people to languish in prison. So any chance to, argue for that.
So how does this community mobilize, mobilize to affect legislation? Where's the organization that can bring us all together so that we can promote legislation? Because that's what it comes down to.
Well, that's a good question. I'll just say one other thing. Is one of the things I think that's really important to do is to encourage more Kelly Loudenbergs. And the reason I say that is that we have to change the narrative. I mean, that's part of what a big meta problem here is the narrative. And that if people need to see more stories like this all the time. I mean, I was not joking when I said, literally, I'll come home from work at night and I'll channel surf, when there's only so many moments that I can listen to all the bad things Donald's doing, and I'm looking for something else. And the number of these crime shows is staggering. There's more crime shows than there are baseball games on it. So, Sam?
Well, he was encouraging my competition, so no, I'm just kidding. I think it's good.
So the National Registry of Exonerations is a research project, and that's important. But the reason we do this research is to affect public policy. So we don't do that directly, but how can other organizations and people do it? Probably the most salient fact about the criminal justice system in the United States, by comparison to other countries, is that it is a deeply political institution. And there are two major foci of the political context in which criminal justice system operates. The first is state legislatures, which Henry's already mentioned. And the second is elected prosecutors. Those elected prosecutors are very likely the more powerful of the two, but those are the two. The state legislatures are the people who set the terms on which convictions are obtained, the lengths of sentences, the rules on discovery. The California state legislature has enacted several significant reforms in the past several years. Most of which were signed by Governor Brown, but not all. So the governor also has a role in that. And those are the ways to do it. How to organize to affect the election of prosecutors and the bills that are passed by legislatures and what the governor will sign. There, I think, we're running out of our expertise.
I think I can take one more question. Back there, Beth?
Hi, I'm Elizabeth Loftus. I have so many questions, I guess. My one thought about Ron's talk is, in addition to you couldn't say the name of your book, if you were asked what courses you taught when you were teaching at UCI, you couldn't name the courses either, because one of his courses was miscarriages of justice. But in any event, Bruce, you were exonerated in 2009, and I'm wondering whether you pursued any civil remedies for compensation, because that seems like it might be one way to get people to wake up if we get bigger and bigger verdicts for people like you.
Yeah. I did. We filed a civil rights lawsuit. Bill Janego, who's passed on, one of the last really huge things that he did was to litigate to the point where the city settled with me for $7.6 million. So.
I have to say something about that, Beth, because that's what I would have thought, that cities like Los Angeles or Chicago or New York would start taking action to prevent the wrongful convictions that result in each of those cities by now hundreds of millions of dollars of judgments paid. As far as I can tell, they make no difference. The people who sign off on those settlements, the city councils, the county commissioners, if it's in counties, are largely playing with other people's money. And there is very little evidence that large settlements and large judgments in these cases make a lot of difference at all. That is a very sad comment on the system, but I wish I could be more optimistic on that.
One of the things you find is that the reaction is that the prosecution will work harder to preserve the conviction because, in effect, it's a cost-effective way of preventing the. But my experience in Chicago is that, they're self-insured, so it comes out of the taxpayer's pocket, and you would think that that would be a cudgel of some sort, but it just, the market's corrected, it doesn't matter.
The other problem
30 million, 40 million, it just doesn't.
The other problem is that many of the states don't have adequate compensation for the number of years one spends in prison. It can vary from a very paltry amount of $10,000 or $20,000 for a lifetime up to significant amounts for each year of prison, including some states now. Texas, which has been one of the wrongful conviction capitals of America in earlier years, has actually come up with some fairly progressive compensation now, including some additional things beyond monetary compensation with job training, an effort to include you in the Texas health care system, educational benefits. So they've actually become one of the more progressive states in terms of recognizing the error of their ways.
Well, again, thank all of you. And